Welcome to the Republican Professor, joining you from Jackson, Tennessee, in the backyard, having a cigar. I'll give you a look at what I'm dealing with. Um, it is 28 December 2025, years after Jesus, and we got a fire going. We have a cigar in the works. It's a Charter Oak Pasquale. Today's topic is a topic that's near and dear to my heart, women in the Second Amendment. We're going to do another one on homosexuals and the Second Amendment, which is about the Democrats' attitude towards self-defense for the most vulnerable. We're going to take a look today at what the Democrats did to Jaime Caetano. Jaime Caetano's story is briefly told by the Republicans in Caetano versus Massachusetts, which is what I would highly recommend that you print out to follow along today. I'm tending to a fire at the same time because I'm cooking burgers today for the fam. So I'm going to be having a cigar and cooking hamburgers, having a fire and a cigar at the same time, multitasking here. I'm not very good at multitasking, but today Uh, it's kind of an emotional topic for me. Cayetano versus United States, or sorry, versus Massachusetts. It's well, just take a look at what they did to Jaime Cayetano. We're going to go through it. How do you get there? You go to Google Scholar, and I'm just going to show you how to get there. I'm going to share my screen. Feel free to call me Sharon. You go to Google Scholar, you go to case law. Hold on. Okay. You hear that bird? This is going to be a large file now because they got all the sounds in Tennessee here. Okay, you go to Google Scholar, you go to case law, you go to federal courts, and you go Cayetano versus Massachusetts, okay? (2016), and it pulls right up. As you can see, it's 577 US 411, Supreme Court 2016. And I have some preliminary remarks that I want to make here. First of all, notice the date. The date is very significant in this. I want you to notice the date. What was the date that Heller versus DC was decided? What was the date of Heller? What was the date of Bruin? They handed those down in June, right around the time Dobbs was, overturning Roe versus Wade. That's when they do the most controversial, the hardest ones. But notice the date here. This is a Second Amendment decision. It's right there, smack dab, in the middle of the semester, March 21st, 2016. What's going on with that? What's going on with that? When did Scalia die? Scalia died in 2016, early in 2016, right? He died on February 13th, 2016. I was in class with Michael Uhlman when he took a call. He never takes calls in class, ever. He took a call from Maureen Scalia, his wife, about the funeral. It's burned into my mind. I was taking admin law, the rise and operations of the administrative state with Michael Uhlman, who served high up in the Ford administration with Scalia as a Senate confirmed official in the Justice Department. Now, notice Caetano is March 21st, 2016. Now, what's the significance of what I'm showing you here? Because in Heller, it was 5-4. In McDonald, 2 years later, it was 5-4. A bare majority. Bare majority. What's the significance of this? Well, if you look at McDonald versus Chicago, and I'm pulling it up. McDonald versus, let me share my screen so you can see. Decided June 28th. See, it's right at the end of the term. Maybe you don't know this, maybe I need to tell you, but the end of the term is the end of June. Okay, so you'll know, go back to Heller, just look it up, June. The very end of June, 2008. 2010, McDonald. Bruin. When was it? When was it decided? When did it come down? It came down the very last week, right at this, almost at the same time the Dobbs decision came down. One day before. Okay. And this is 5-4. By the way, Stephen Hallbrook, two-time guest on this podcast. Yeah. Look. It's Alito, Roberts, Thomas, this is McDonald versus Chicago. So you got Alito, Thomas, Roberts, and you've got let me let you look at the fire here while I get the 5-4 majority here. Okay. You've got Scalia. You've got Thomas. You've got Kennedy. Remember that guy? You've got Roberts and Alito in the majority there. Okay? Scalia dies February 2016. Caetano is in the pipeline already. They issue a per curiam decision. What's per curiam? It means they're not going to tell you who signed on to it. They're not going to tell you who is writing it. All you know is that there is a majority of the court. That's all you know. That's all they're telling you. They're saying the court is speaking with one voice here. See if there are any dissents, see those. Okay. There are two concurrences here. Oh, sorry, there is one concurrence, two people joining. That's very important. But what you know is that there are 4 Republicans and 4 Democrats at this time. That's all you know. Okay? Scalia dies. Obama is president. 4 of the people in that court disagreed with the precedent that this is based on. You're going to have a tie here, which means the lower court wins, which means Jaime Caetano continues to get abused by Democrats. One of the Democrats, or more, at least one, came over to the Republican side. That's what that means. And they wanted to bury it in the middle of the term and not make a big deal of it. The court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, citing Heller, which half of the court disagreed with at this time. Okay? And that this Second Amendment right is fully applicable to the states. Again, half of the court here disagreed with that. The 5th vote, Scalia, has died. One of the Democrats came over to the Republican side. That's all we know. In this case, the Supreme Judicial Court of Massachusetts, think that's code for Democrat, upheld a Massachusetts law, that's code for Democrat, prohibiting the possession of stun guns after examining whether a stun gun is the type of weapon contemplated by Congress in 1789 as being protected by the Second Amendment. The court offered 3 explanations to support its holding that the Second Amendment does not extend to stun guns. First, the court explained that stun guns are not protected because they are not in common use at the time of the Second Amendment's enactment. This is inconsistent with Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. Did you hear that? Stun guns are not protected because they were not in common use back when George Washington was alive. That's what they really said. Response from the court, this is inconsistent with Heller, which again, 4 people on the court would disagree with. Clear statement that the Second Amendment extends to arms that were not in existence at the time of founding. Heller was written by Scalia. He's gone. He's dead. One of the Dems came over. Oh. You hear that? There's a robin. Man, I miss robins. I grew up in Colorado and I used to hear that all the time. I miss it. Oh, man. You know, don't you miss the robins? I put another one on here. Get that nice and... Might be time for me to get the charcoal on that sucker. That gum robin's interrupting me. Yeah, so stun guns were not in existence, so they're not protected. The court says, yeah, that goes against exactly what the court said just a few years ago. In other words, you obviously don't want to protect this lady. The court next asked whether stun guns are dangerous per se at common law and unusual in an attempt to apply one important limitation on the right to keep and carry arms, referring to the historical tradition of prohibiting the carrying of dangerous and unusual weapons. In doing so, the court concluded that stun guns are unusual because they are a thoroughly modern invention. With that rationale, what could possibly go wrong? By equating unusual with in common use at the time of the Second Amendment's enactment, the court's second explanation is the same as the first. It is inconsistent with Heller for the same reason. Finally, the court used a contemporary lens and found nothing in the record to suggest that stun guns are readily adaptable to use in the military. But Heller rejected the proposition that only those weapons useful in warfare are protected. Okay, for these reasons, look how short this is. For these reasons, the explanation that the Massachusetts court offered for upholding the law contradicts this court's precedent. Consequently, the petition for writ of certiorari and the motion for leave to proceed forma pauperis are in forma pauperis are granted. The judgment of the Supreme Judicial Court of Massachusetts is vacated, and the case is remanded for further proceedings not inconsistent with this opinion. Okay, notice there's no facts of the case at all here. Whatever Democrat signed on to this was like, don't share the facts of the case. Do not say anything about what the Democrats did to this woman, Jaime Caetano. I'm not going to sign on to it. If you put it like this, fine. Fine. Now let's take a look at the facts. You got Alito and Thomas, two Republicans, saying, let's look at what the Republicans did. What the Democrats did to this woman. After a bad altercation with an abusive boyfriend put her in the hospital, Jaime Caetano found herself homeless. I'm pissed already, dude. I already know where this is going. I'm pissed already. You know why? I'm going to tell you why. It's always the same story. Criminalization of innocent conduct. It's always the same damn story. Every tyranny, every tyranny does this. They criminalize self-defense. They criminalize free speech. They criminalize stuff that should not be criminalized. It's innocent conduct not to buy health care. You know, it's pretty basic stuff. It's innocent conduct what the Democrats have wanted to criminalize. Let's keep going. You're probably thinking, share more of Jaime. So her abusive boyfriend put her in the hospital. She was homeless and in fear for her life. She obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, Caetano accepted the weapon. Keep this in mind when someone says they want common sense safety regulation. This is what they mean by common sense, criminalizing innocent conduct. Caetano accepted the weapon. That's common sense to me. That's common sense. She's in fear for her life. She's extremely vulnerable, and the law is not protecting her. The police are not protecting her. It is a good thing she did. One night after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was not gonna, expletive deleted, work at this place anymore because she would be home with the kids they had together. She should be at home with the kids they had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. But she didn't need physical strength to protect herself. Why would that be? She stood her ground, displaying the stun gun. She didn't even have to use it. Well, she was using it in the sense that displaying it is using it, but she didn't have to deploy the weapon. She was using it in a display manner only, in the least offensive way possible, purely for self-defense. She displayed the stun gun and announced, "I'm not going to take this anymore. I don't want to have to use this stun gun on you, but if you don't leave me alone, I'm going to have to." The gambit worked. The ex-boyfriend got scared and he left her alone. Now, remember, it's not Democrats concurring here and saying, let's explain here, we're protecting women. It's Republicans that are doing that here. And some of you guys have a shell, like a concrete shell, and it needs to be broken down, and you need to be able to take in the information I'm saying. It's not that the information isn't out there or inaccurate, it's that you're not taking it in. Let's keep going. It is settled that the Second Amendment protects an individual right to keep and bear arms that applies against both the federal government and the states. That right vindicates the basic right of self-defense, individual self-defense. Caetano's encounter with her violent ex-boyfriend illustrates the connection between those fundamental rights. By arming herself, Caetano was able to protect against a physical threat that restraining orders had proved useless to prevent, and commendably she did so by using a weapon that posed little, if any, danger of permanently harming either herself or the father of her children. I'm going to put more wood on the fire. I'll be right back.
Recording in progress.
All right, back. So, let's continue here. Under Massachusetts law, however, Caetano's mere possession of the stun gun that may have saved her life made her a criminal. Really? Really? How's that work? How does owning something make you a criminal? I thought, this whole time, I thought it was something you had to do. Something wrong that made you a criminal. That's the classic understanding of criminal law. Is it's an overt act that you did. In the case of negligence, it might be an omission. But it's something you were supposed to do, that you knew about. So how is merely owning something for self-defense a criminal thing? That's brand new. When police later discovered the weapon, she was arrested, tried, and convicted. The Massachusetts Supreme Judicial Court affirmed the conviction, holding that a stun gun is not the type of weapon that is eligible for Second Amendment protection because it was not in common use at the time of the Second Amendment enactment. So because Benjamin Franklin hadn't invented it and sold it widespread, you're a criminal, Jamie, for defending yourself. The most vulnerable person that you can imagine is criminalized for innocent conduct. And that's what this is innocent conduct. The criminalization of innocent conduct creates criminals where there were none before. When police later discovered the weapon, she was arrested. Okay. The reasoning defies our decision in Heller, which rejected as bordering on the frivolous the argument that only those arms in existence in the 18th century are protected by the Second Amendment. The decision below also does a grave disservice to the vulnerable individuals like Caetano, who must defend themselves because the state will not. Or they just must defend themselves because the state can't. Do we really want an omnipresent state? That's not the function of the state. The events leading to Caetano's prosecution occurred sometime after the confrontation between her and her ex-boyfriend. Listen to this. In September 2011, police officers responded to a reported shoplifting in Ashland, Massachusetts supermarket. The store's manager had detained a suspect, but he identified Caetano and another person in the parking lot as potential accomplices. Police approached the two and obtained Caetano's consent to search her purse. They found no evidence of shoplifting, so it's mistaken. It's mistaken entirely. By the way, this is, every defense attorney is thinking, don't give consent. Don't do it. But she didn't think she had anything to hide. Why? Because she's using common sense. Remember common sense gun safety legislation? Remember that? It's not common sense. It's criminalization of innocent conduct is what it is. You think you can trust the police? Not necessarily. Not in Democrat states you can't. They're crazy. The laws are crazy. You wouldn't believe how many posts come up in my feed, just because I respond to them, of random police agencies displaying photos of guns they seized off the streets. And the only photo is only of a gun, only of ammunition, as if they just saved. It's like they stormed the beach at Normandy. They could have taken that off of an innocent person who needed that for self-defense. And they're pounding their chest like a gorilla, like they just defeated Darth Vader or something. It's that mentality. I'm talking like NYPD. I'm talking about these Democrat areas. Blue Bloods is a Republican show. The very first episode is about exactly this: criminalization of innocent conduct. They found no evidence of shoplifting, but saw Caetano's stun gun. Caetano explained to the officers that she had acquired the weapon to defend herself against a violent ex-boyfriend. The officers believed Caetano. Now listen to this. They believed her. But, there's a big but right here. There's a big but coming down the aisle at First Cafeteria. There's a big but. The officers believed Caetano, but they arrested her for violating Massachusetts General Law, Chapter 140, Section 131J, which bans entirely the possession of an electrical weapon. When Caetano moved to dismiss the charge on Second Amendment grounds, now she likes the Second Amendment. She probably wasn't voting Republican before. Maybe she was. Maybe, I don't know. There's 40%. 35-40% that do. They're in the minority. When Caetano moved to dismiss the charge on Second Amendment grounds, the trial court denied the motion. A subsequent bench trial established the following undisputed facts. The parties stipulated that Caetano possessed the stun gun and that the weapon fell within the statute's prohibition. The Commonwealth also did not challenge Caetano's testimony that she possessed the weapon to defend herself against the violent ex-boyfriend. She's defending herself against deadly crime. The crime which is the heart and soul of the criminal law. Take, for example, Exodus 20. Thou shalt not murder. Thou shalt not steal. That's a very old law. That's the heart and soul of the criminal law. If you look at the common law written by Justice Oliver Wendell Holmes, just look at his section on the criminal law. It's not very long. It's not that complicated. It's only complicated when you add crap that shouldn't be there. In other words, when you criminalize innocent conduct, like minding your own business. Minding your own business, not buying health insurance. And then all of a sudden, oh, you can't do that. That's criminal. We're going to enforce that with guns. I'm going to throw you in prison. We're going to take money out of your bank account. The trial court nonetheless found Caetano guilty, and she appealed to the Massachusetts Supreme Judicial Court. The Supreme Judicial Court rejected Caetano's Second Amendment claim, holding that the stun gun is not the type of weapon that is eligible for Second Amendment protection. The court reasoned that stun guns are unprotected because they are not in common use at the enactment of the Second Amendment, and because they fall within the traditional prohibition against carrying dangerous and unusual weapons. Although the Supreme Judicial Court professed to apply Heller, each step of its analysis defied Heller's reasoning. The state court repeatedly framed the question before it as whether a particular weapon was in common use at the time of the enactment of the Second Amendment. In Heller, we emphatically rejected such a formulation. We found the argument that only those arms in existence in the 18th century are protected by the Second Amendment not merely wrong, but bordering on the frivolous. Instead, we held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Hello? It is hard to imagine language speaking more directly to the point, yet the Supreme Judicial Court did not so much as mention it. I'm going to put some coals on this fire. Hang on. You guys with me still? Let's continue. All right. Instead, the court seized on language originating in United States versus Miller from 1939, the Great Depression, before World War II, that the sorts of weapons protected were those in common use at the time. That quotation does not mean, as the court below thought, that only weapons popular in the 1789 are covered by the Second Amendment. It simply reflects the reality that the founding era militia consisted of citizens who would bring the sorts of lawful weapons they possessed at home to militia duty. Hello? Look at the lengths that these guys are going to keep this woman disarmed from violent crime. This shows you their heart. It's not protective of the vulnerable. By their fruits ye shall know them. You got to take it in, guys. You got to take it in, what I'm saying. Listen to this. The Second Amendment accordingly guarantees the right to carry weapons typically possessed by law-abiding citizens for lawful purposes. Is self-defense a lawful purpose? Yeah. Yeah, it is. While stun guns were not in existence at the end of the 18th century, the same is true for the weapons most commonly used today for self-defense, namely revolvers and semi-automatic pistols. Revolvers were virtually unknown until well into the 19th century, and semi-automatic pistols were not invented until nearly the end of that century. Electronic stun guns are no more exempt from the Second Amendment's protections simply because they were unknown to the First Congress. Then electric communications are exempt from the First Amendment, and electronic imaging devices are exempt from the Fourth Amendment. As Heller aptly put it, we do not interpret constitutional rights that way. The Supreme Judicial Court's holding that stun guns may be banned as dangerous and unusual fares no better. As the per curiam opinion recognizes, this is a conjunctive test. A weapon may not be banned unless it is both dangerous and unusual. Because the court rejects the lower court's conclusion that stun guns are unusual, it does not need to consider the lower court's conclusion that they are also dangerous. But make no mistake, the decision below gravely erred on both grounds. All right, we don't have that much longer here. As to dangerous, the court below held that a weapon is dangerous per se if it is designed and constructed to produce death or great bodily harm and for the purpose of bodily assault or defense. Wouldn't that include all weapons? Just questioning. I mean, isn't that the concept of a weapon? Isn't that the whole point of a weapon? Any weapon? That the test may be appropriate for applying statutes criminalizing assault with a deadly weapon. That test may be appropriate for applying statutes criminalizing assault with a deadly weapon, a dangerous weapon, but it cannot be used to identify arms that fall outside the Second Amendment. First, the relative dangerousness of a weapon is irrelevant when the weapon belongs to a class of arms commonly used for lawful purposes. Second, even in cases where dangerousness might be relevant, the Supreme Judicial Court's test sweeps far too broadly. Heller defined the arms covered by the Second Amendment to include anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. Under the decision below, however, virtually every covered arm would qualify as dangerous. Now, that's a reductio ad absurdum, because if the Second Amendment does anything, it protects arms for somebody, right? Even if you get the somebody wrong, as the dissent did in Heller. Were there any doubt on this point, one need only look at the court's first example of dangerous per se weapons, firearms. If Heller tells us anything, it is that firearms cannot be categorically prohibited just because they are dangerous. A fortiori, stun guns that the Commonwealth's own witness described as non-lethal force cannot be banned on that basis. The Supreme Judicial Court's conclusion that stun guns are unusual rested largely on the premise that one must ask whether a weapon was commonly used in 1789. As already discussed, that is simply wrong. The court also opined that a weapon's unusualness depends on whether it is a weapon of warfare to be used by the militia. It asserted that we followed such an approach in Miller and approved its use in Heller. But Heller actually said that it would be a startling reading of Miller to conclude that only those weapons useful in warfare are protected. Now that's very awkward if you like the NFA and the subsequent legislation that restricted machine guns. I mean, wouldn't you say? Okay. Instead, Miller and Heller recognized that militia members traditionally reported for duty carrying the sorts of lawful weapons that they possessed at home, and that the Second Amendment therefore protects such weapons as a class, regardless of any particular weapon's suitability for military use. By the way, virtually every weapon that we have was used by the military at some point. I have an M&P revolver, Smith & Wesson, that's decades old. M&P means military and police. That's what M&P means. Hello? Indeed, Heller acknowledged that advances in military technology might render many commonly owned weapons ineffective in warfare, but such modern developments cannot change our interpretation of the right. In any event, the Supreme Judicial Court's assumption that stun guns are unsuited for militia or military use is untenable. Section 131J allows law enforcement and correctional officers to carry stun guns and tasers, presumably for such purposes as non-lethal crowd control. Subduing members of a mob is little different from suppressing insurrections, a traditional role of the militia. See U.S. Constitution Article 1, Section 8, Clause 15. Additionally, several branches of the U.S. Armed Services equip troops with electrical stun weapons to incapacitate a target without permanent injury or known side effects. That's from the U.S. Army Project Manager Close Combat Systems, PD Combat Munitions. And there's a source there. The boss is calling me. Hold on. Okay, got the burgers on the grill there, buddy. So I'm multitasking here. I want you to see that. They're all waiting for their food. They're a bunch of daggone farmers, and they eat exactly at 5 o'clock, so. All right. Now, there's the salt of the earth, so I can't complain here. Very supportive of TRP here. So let's keep going here. So the military use them, the police use them. That doesn't stop the Democrats. They were using anything to try to disarm this vulnerable woman from her being able to defend herself against violent crime. They will make up stuff. They'll just lie. And the Republicans are saying no. As the foregoing makes clear, the pertinent Second Amendment inquiry is whether stun guns are commonly possessed by law-abiding citizens for lawful purposes today. The Supreme Judicial Court offered only a cursory discussion of that question, noting that the number of tasers and stun guns is dwarfed by the number of firearms. This observation may be true, but it is beside the point. Otherwise, a state would be free to ban all weapons besides handguns, because handguns are the most popular weapon chosen by Americans for self-defense in the home. The more relevant statistic is that hundreds of thousands of tasers and stun guns have been sold to private citizens who, it appears, may lawfully possess them in 45 states. Okay, we got a lot of quotations and citations. Okay, acknowledging that approximately 200,000 civilians owned stun guns as of 2009. While less popular than handguns, stun guns are widely owned and accepted as a legitimate means of self-defense across the country. Massachusetts' categorical ban of such weapons therefore violates the Second Amendment. It's also self-defense. It's used by self-defense by law enforcement. That's why law enforcement is armed. It's for self-defense. It's the same reasoning. The lower court's ill treatment of Heller cannot stand. The reasoning of the Massachusetts court poses a grave threat to the fundamental right of self-defense. The Supreme Judicial Court suggested that Caetano is a woman defending herself, could have simply gotten a firearm to defend herself. The Supreme Judicial Court suggested that Caetano could have simply gotten a firearm to defend herself, But the right to bear other weapons is no answer to a ban on the possession of protected arms. Moreover, a weapon is an effective means of self-defense only if one is prepared to use it, and is presumptuous to tell Caetano that she should have been ready to shoot the father of her 2 young children if she wanted to protect herself. Courts should not be in the business of demanding that citizens use more force for self-defense than they are comfortable wielding. Countless people have reservations about using deadly force, whether for moral, religious, or emotional reasons, or simply out of fear of killing the wrong person. I am not prepared to say that a state may force an individual to choose between exercising that right and following her conscience, at least where both can be accommodated by a weapon already in widespread use across the nation. A state's most basic responsibility is to keep its people safe, not to criminalize innocent conduct. That's me, the last part. The Commonwealth of Massachusetts was either unwilling or unable to do what was necessary to protect Jaime Caetano, so she was forced to protect herself. To make matters worse, the Commonwealth chose to deploy its prosecutorial resources to prosecute and convict her of a criminal offense for arming herself with a non-lethal weapon that may have saved her life. The Supreme Judicial Court then affirmed her conviction on the flimsiest of grounds. This court's grudging per curiam, and this is very important detail right here, this court's grudging per curiam. Notice, no Democrat was willing to put their name on this. In other words, they couldn't bear to do the grave injustice of seeing Caetano, a woman, wrongly convicted, and it's wrongly convicted because the law is wrong, but they didn't have the balls to put their name on it. Now sends the case back to that same court, and the consequences for Caetano may prove more tragic still, as her conviction likely bars her from ever bearing arms for self-defense. That is, until this decision. It is the fundamental right of self-defense. If the fundamental right of self-defense does not protect Caetano, then the safety of all Americans is left to the mercy of state authorities, who may become more concerned about disarming the people than about keeping them safe. That's all I got tonight on the Republican Professor podcast, coming to you from Jackson, Tennessee. It is 28 December 2025, years after Jesus. It's a Sunday. Merry Christmas, guys. Talk to you soon.